Hello and welcome. This is Exoneree. My name is John, your personal economist and philanthropist, whose life has exposed me to the many shortcomings and miscarriages of justice that this world has to offer. The purpose of this channel is to tell the story of exonerees. In other words, tell the stories of people who were wrongfully convicted of crimes and spent time in prison. As I mentioned, I'm a philanthropist, so any proceeds I receive from this podcast go to my charity, Reform Foundation, where I help people with criminal records get jobs and maintain employment. I'm also an economist, and as you'll soon find out, on this episode, I will go over a lot of statistics, so just a heads up. Please like and subscribe. All right, so this time around, we're traveling to Canada, and this particular exoneree identifies as an Indigenous woman, so her people are native to Canada. I thought it was important to touch on this topic in my first episode in Canada. I knew Canada had its issues with its Indigenous women going missing. You've probably come across a few YouTube videos that talk about the Highway of Tears, so I knew that was an issue, but I had absolutely no idea about the staggering statistics on incarcerated Indigenous women and the issues they go through in Canada. So we'll be going through a lot of that in this episode, along with the story of our exoneree number 3, Connie Oakes. Connie Oakes had lived a difficult life. Hailing from Nekaneet First Nation in southern Saskatchewan, she would later recall both an idyllic childhood, picking berries and riding horses, but also a darkness shrouding her early years. In order to escape sexual abuse from an older cousin, she chose to attend the Lebret Indian Residential School, where she was again abused. After leaving school at age 18, she had difficulty securing stable work and struggled with drug addiction. By 2011, Oakes had a lengthy criminal record. Early that year, she first met Wendy Scott in order to purchase some crack from her. Oakes later recounted that, surprisingly, Scott gave her the crack for free simply because they had a mutual acquaintance. In May 2011, Oakes invited Scott to stay in her trailer home after the mutual acquaintance told her that Scott was homeless and had no place to go. Casey Armstrong, a 48-year-old man from Medicine Hat, Alberta, was found murdered in the bathtub of his trailer home on May 22, 2011. He had been stabbed to death. Armstrong was last seen on Friday, May 20th at a local pub. He left at around 11 p.m., telling the pub manager, Terry Lynn Russell, that he was going to watch a hockey game. The next day, Russell saw two women, one of whom had, quote, reddish hair, outside Armstrong's trailer. Russell's impression was that both women were white. They were placing a garbage or duffel bag into the trunk of a red car. On Sunday, a friend of Armstrong's went to his residence, having tried to contact him several times with no response. He found Armstrong's body and called 911. Initially, the Medicine Hat police investigation met with little success. No DNA samples or fingerprints were retrieved from the scene. Investigators found a bloody footprint but were unable to identify the matching footwear. Police interviewed the former owner of the red Grand Am that they believed had been outside Armstrong's home. However, she had sold the car before the murder to a drug dealer known to her only as Ginger, quote. Police were never able to locate the car. The police ran out of leads after 8 months investigating the murder. A different officer, Sergeant Brent Secondiak, was then tasked with leading the investigation. Sergeant Secondiak reviewed the evidence and honed in on statements made by 29-year-old Wendy Scott, who had been interviewed between December 6 and 7, 2011. At that time, police had concluded that Scott was not connected to Armstrong's murder, but Sergeant Secondiak believed that she had lied in her statements. At least one confidential source had provided information linking both Scott and Connie Oakes to the killing. An inmate at the Edmonton Institution for Women told police in December 2011 that Oakes, who was also serving a sentence there, had confessed to the crime. The inmate also claimed to have seen Scott and Oakes driving in a red car together. Upon concluding that Scott had lied in her police statements regarding Armstrong's murder, Sergeant Secondiak decided to charge her with obstruction. Scott was arrested on January 10, 2012, and interviewed again. Scott, who had a severe intellectual disability, struggled greatly with learning and processing information. She would later be assessed as having an IQ of 50, with verbal comprehension and functional memory scores at the .1 and .3 percentile rank, respectively. Scott had an inability to understand and recall complex matters, quote, and would often become confused regarding straightforward subjects. She tended to mix up times and events. Scott's friends knew her as, quote, kind-hearted girl who would do anything for anybody, but was easily used and known for lying. So here we go again. Is this another case of a habitual liar, another case of false confessions? So let's see. In the course of Scott's several police interviews, officers told her a number of falsehoods: that Oakes had named her as the killer, that Scott's DNA had been found in Armstrong's home, and that a surveillance disc showed her involvement, in support of which a dummy disc and surveillance report were brought in as interview props. So, yep, here we go again with the tactics of police trying to coerce a mentally disabled woman into a false confession who doesn't have a lawyer present. If you go back to my first episode about Sean Hodgson, this is very similar, as he was a known habitual liar as well. At first, Scott named 3 different people, one of whom was, quote, Ginger, her name was Ginger, in connection with Armstrong's murder. Later, she changed her story, stating that Oakes and Scott had gone to the trailer together, and Oakes had then killed Armstrong while Scott stood by. Both women were arrested and charged with first-degree murder. On November 8, 2012, Scott pled guilty to second-degree murder in exchange for the Crown's agreement to drop the first-degree murder charge against her. A statement of facts supporting her plea was read to the court. The statement asserted that Scott and Oakes had entered Armstrong's home, where Oakes had stabbed Armstrong, and that Scott had then helped her to clean up the crime scene. Scott was sentenced to life in prison with no parole eligibility for 10 years rather than 25, which is what she would have faced if convicted of first-degree murder instead. Oakes, however, maintained her innocence and stood trial for Armstrong's murder. Scott, the Crown's star witness, gave the, quote, only evidence identifying Oakes as the murderer. As Scott's testimony unfolded, numerous problems emerged. Her account was internally inconsistent, contradicting itself on many occasions. Her story evolved in real time and changed significantly under cross-examination. Moreover, Scott herself stated that she had lied, sometimes under oath several times. Indeed, the Crown acknowledged that Scott's demeanor was childlike, but argued that this fact enhanced rather than undercut the weight that the jury should place on her evidence. On November 15, 2013, the jury found Oakes guilty of second-degree murder. She was sentenced to life imprisonment with no chance of parole for 14 years. Shortly after Oakes' conviction, she had not yet had her sentencing hearing. Scott called Kim Pate, then the director of the Elizabeth Fry Society, a support and advocacy organization for incarcerated women, to ask for her help. She told Pate that she did not believe that Oakes had murdered Armstrong. Scott also retained counsel, Deborah Hatch, and swore an affidavit that she had falsely confessed because she was, quote, very scared and wanted to, quote, be safe. She stated that police had told her she would receive a 25-year prison sentence unless she confessed to the crime. In addition, Hatch realized that the statement read out to support Scott's guilty plea did not disclose a proper basis for her conviction. As Hatch put it, simply going along with someone who allegedly committed a homicide is not being party to murder. The trial judge had therefore erred in accepting Scott's guilty plea, since the evidence before the court did not, in fact, establish her guilt. Scott appealed her conviction to the Alberta Court of Appeal. The Crown conceded the appeal in light of this serious legal error. On October 16, 2015, the court overturned Scott's conviction and ordered a new trial. In light of these events, Oakes then appealed her conviction as well. She requested that the Alberta Court of Appeal consider the fresh evidence of Scott's successful appeal, recantation of her false confession, and the manner in which the police had elicited this confession from a woman with significant cognitive difficulties. Oakes was denied bail pending appeal. Her application to the parole board for compassionate leave to visit her son Joseph, who was dying of cancer, was also denied. Joseph passed away at age 22 while Oakes was incarcerated. She was not permitted to attend his funeral. On April 6, 2016, a 2-1 majority of the Court of Appeal found that Oakes' conviction was a miscarriage of justice and ordered a new trial. The dissenting judge would have upheld the conviction. The majority found that to reach this decision, it needed to consider the fact that Scott's conviction had been overturned. The Crown, at Oakes' trial, had placed repeated emphasis on Scott's own guilty plea to the murder as vouching for the testimonial truthfulness. Oakes's conviction could not stand given the jury's potential reliance on Scott's guilty plea as support for her frail evidence. The majority also took particular note of Scott's having identified Oakes, quote, only after the police lied, basically, and told her own DNA was found in Armstrong's trailer and that Oakes had said that she was responsible. Rather than try her a second time, the Crown suspended the proceedings against Oakes on April 28, 2016. Meanwhile, Scott remained behind bars, waiting for her new trial to move forward. For months, the Crown did not fulfill its obligation to disclose the required materials for defense counsel's trial preparation, despite being criticized by the court for this delay. Finally, on January 13, 2017, so 15 months after her conviction had been overturned, the Crown suspended the charge against Scott as well. Police claimed that after Scott's proceedings were suspended, that they had not known of her cognitive problems when interviewing her because, quote, she did not present herself to the investigators as someone who was developmentally delayed. In an excerpt from their interrogation videos that has been made public, however, Scott says to police that she lied, quote, my whole life pretty much. When asked why she would seek this form of attention, Scott responds, I don't know, psychiatrist, I don't know. Shortly after, she explains that, quote, every time I get things mixed up in my own head, and that's why I've been in special needs, because I get things mixed up in my own head. Kim Pate, who had since been appointed to the Senate, called for a public inquiry into Oakes's and Scott's wrongful convictions. She stated that both women, their families, and Armstrong's family all deserve to know how this miscarriage of justice came about. Pate further observed that, quote, prosecutors are supposed to be officers of the court, not individuals who are seeking convictions at all costs. Exactly right. I mean, that is the point. In May 2018, the Alberta Department of Justice issued a short statement that no inquiry would be held. Oakes filed a statement of claim for malicious prosecution against the Crown and Medicine Hat Police Service, asking for $1 million to compensate her for the wrongful conviction and incarceration. The Alberta Court of Queen's Bench dismissed the lawsuit in May 2019. Casey Armstrong's murder remains unsolved. So I'm guessing that she did not receive the $1 million, and obviously they did not find out who murdered Casey. All right, but let's back up. I can't be the only person who remembers this girl named Ginger who bought the red Grand Am. Okay, the police said they never found the Grand Am, but we don't even get the name of the person who previously owned the car. This person who previously owned the car must know who Ginger is. Ginger's name is again brought up as one of the first people that Wendy Scott says committed the murder on Casey Armstrong. So who is she? With a name like Ginger, she obviously has or had red hair, and the only so-called witness, Terry Lynn Russell, who claims to have seen two women, one with red hair, leaving Casey Armstrong's trailer the morning after the murder, we have not heard about her either. And on top of everything, we do not have any physical evidence. If they did not find Scott's DNA at the murder scene, whose DNA did they find? I feel like I'm beating a dead horse here, going around and around in circles. This is only my third episode, and it's basically the same old story. Police dragging out false confessions, no physical evidence, only one so-called witness that is not in the least bit credible. So I really, really hope that I can get a chance to speak with Connie Oakes, because at least in my first two episodes, those exonerees received some compensation. Any exoneree story is really sad, but now I'm going to talk about the plight of Indigenous women in Canada's judicial system. So about 3% of women in Canada are Indigenous, yet they comprise 50% of the incarcerated female population. Let me repeat that. So about 3% of women in Canada are Indigenous, yet they comprise 50% of the incarcerated female population. The overrepresentation of Indigenous people in Canadian prisons has led some to describe them as, quote, new residential schools. Imprisoned Indigenous women experience high rates of self-harm and are often placed in higher security environments than their non-Indigenous counterparts. They are more likely to suffer harsh conditions, including prolonged solitary confinement, which has been internationally condemned as a form of torture. Indigenous women experience wrongful convictions in the context of pervasive issues of colonialism, racism, and systemic discrimination. Many also face intersectional disadvantages that negatively affect court outcomes, for instance, pressure to plead guilty to domestic violence charges despite having acted in self-defense in order to protect Indigenous loved ones from imprisonment, and false guilty pleas are an issue in and of itself. In the last episode, I said in a tongue-in-cheek way that I heard that if you're guilty, use a public defender. If you're not guilty, get a private lawyer. But this is no laughing matter, because the premise behind that saying is that a public defender will always want you to plead guilty for a lesser sentence. They don't want to go to trial, and if they do go to trial with you, 9 times out of 10, they will represent you badly and you will lose, as was the case with Gerard Damone on the last episode. But who can afford a private attorney? Not only that, but if you are guilty and you can afford a private attorney, 9 times out of 10, they will get you off. That is why certain types of people don't go to jail. Further incentives to plead guilty include the disproportionate rate at which Indigenous women are denied bail, disadvantaged in the justice system due to a criminal record, subjected to abusive treatment in prison, and alienated from the hostile colonial justice system such that it seems fruitless to engage with this process. It is likely, in light of these barriers, that a large number of Indigenous women's wrongful convictions have yet to be recognized and may never be rectified. Indigenous men, too. They represent 30% of male prison admissions, despite making up only 3% of the Canadian male population. Not as high as the women, but they still represent the highest demographic in the Canadian prison system. Canada is a much smaller country with regards to population in comparison to the United States. However, 50% is crazy for one ethnicity to be incarcerated, especially the Indigenous people. Everywhere in the world, the Indigenous people are mistreated in one way or another. In the United States, with the Native Americans, even the Mexicans are Indigenous, the Aborigines, the list goes on and on. Literally everywhere in the world that has been colonized, the natives got the short end of the stick. Now, I said Canada has a smaller population to lead off with because I'm about to give you some numbers to compare with to the United States. All right, so according to Statistics Canada, as of 2018-2019, there were a total of 37,854 adult offenders incarcerated in Canadian federal and provincial prisons on an average day, for an incarceration rate of 127 per 100,000 population. In other words, if you included every single person in Canada, 0.127%, which is less than 1%, in other words, 1/13% of everyone is incarcerated on a given day. But if we go to the U.S., our incarceration is 1,516 per 100,000, or 1.5% of all people on any given day is incarcerated, which is about 12 times higher, or you are 12 times more likely to end up in jail in the USA than in Canada. Now, that's for everybody, but for example, in America, for black men, that number jumps from 1.5% to 4.3%. And if you're a white man, that number drops from 1.5% to 0.68%. So you can see how your chances of being incarcerated fluctuate depending on who you are, and it would do the same in Canada for Indigenous women. I just don't have those numbers. Now, if you talk about the United States, I don't know about you, but in my mind, I always had this idea that there are about 10% of black people represent the whole population of the United States. And if you look at just the population of people that are in prison, that 30% of those people are black. Which is crazy that I have normalized that, but I was like, okay, there's something like probably 70% of people that are white in all the United States population, and they probably make up about 55% of the incarcerated population. My point being, I always thought that white people made up the highest rate of incarcerated people. But in actuality, these are the statistics. People incarcerated in state or federal prisons by race and ethnicity. There are 59% of the U.S. population are white people, 19% are Hispanic, and 14% are black. But the percentage of incarcerated people to the incarceration population, 31% are white, 24% are Hispanic, and 32% are black, which means black people make up the highest number of the incarcerated population. So if anyone tells you that 50%, 30% that I was talking about before, they're talking about federal prison by itself. In federal prison, there are 56.8% are white and 38.7% are black. I cannot find people incarcerated in the state and federal prisons by gender and race and ethnicity. I just wanted to put that out there, that black people are the minority in the U.S. population, but they are the majority in the U.S. prison population. If it weren't for this episode, I wouldn't have looked into that, but I'm glad I did. However, it's nowhere near the disparity for the Indigenous people, particularly the Indigenous women in Canada. And I'll just wrap it up there. Did want to go over Canada's compensation guidelines versus the United States. However, it really just boils down to getting an attorney, which if you have reached the exoneration phase, you will have plenty of attorneys who will represent you pro bono for a piece of your claim settlement. All right, and that concludes episode 3 of Exoneree. This was Exoneree number 3, Connie Oakes. And again, last episode, I said if you're guilty, get a public defender, and if you're innocent, get a private lawyer. But actually, if you're guilty, get a public defender. But if you're innocent and can't afford a private lawyer, still get a public defender in the meantime, but do not plead guilty. If you're innocent, never plead guilty. Do not take that plea. If you're innocent, you'll work your way as hard as you can and find somebody to do that for you pro bono, because if you're innocent, that's all that matters. There's no reason for you to go to jail for something you didn't do. And with that, like I said, that's the end of the episode. Just putting that out there. I can be reached at exoneree@gmail.com. That's XZONORY@gmail.com. My name's John, and whatever you do, don't get arrested.